This presentation discusses the High Court test case of Telstra and Australasian Performance Rights Association, or APRA. APRA owned and assigned copyrights in a number of musical and literary works. The question the High Court was called to consider was whether Telstra, in playing some of these musical works on their hold services, infringed APRA's exclusive right to broadcast the work under Section 31, subsection 1A4 of the Copyright Act 1968. Broadcast was defined in Section 10, subsection 1, to mean to transmit by wireless telegraphy to the public. The only issue in contention was the scope of the term "to the public." This was particularly difficult to determine in the case of a broadcast to a limited class of persons, as was the case with Telstra's broadcast of the pieces to a select group of their customers who had contacted them by mobile telephone. To assist their determination of the contended issue, the High Court looked to case law. In Duck and Bates, it was held the representation must be other than domestic and private. In Harms Incorporated and Chappell & Co. and Martin's Club, it was held that one must apply one's mind to see whether there has been any injury to the author, and whether what took place interfered with his proprietary rights. In this context, profit was an important element. The High Court expressed the view that the legislative history of the definition of broadcast indicated the phrase "to the public" referred to the notion of the copyright owner's public. In other words, the group which the copyright owner would otherwise contemplate as its public for the performance of its work. Of particular relevance to this principle was the case of Rank Film Product and Dodds, which involved the playing of films transmitted by a video cassette recorder to television sets in motel rooms. Justice Rath in this case observed that it is not the restricted size of the audience or the privacy of the surroundings that is decisive on the issue. The critical matter is the presentation of the movie by the occupier of the motel to his guest in that capacity. The number of guests playing films in their rooms was not large, but the motel was open to the paying public. Therefore, the subject broadcast was transmitted to the public. From this case, the High Court in Telstra and APRA determined transmissions could be to individuals in private circumstances, but nevertheless be to the public. It did not matter that those in a position to receive the transmission formed only a part of the public, though it was necessary that the facility be available to those members of the public who chose to avail themselves of it. Justice Kirby, in consideration of this case law, identified three broad principles. These were whether the performance is domestic or private in character, whether the performance occurred as an adjunct to a commercial activity, and whether the relevant public forms part of the copyright owner's public. In applying these principles, the High Court held music on hold was played by organisations to entertain, placate, or distract customers in a way hoped to be congenial to them, while the telephone lines were engaged. Telstra played it as art of its overall telephonic communications enterprise, and despite those members of the public who chose to call the relevant Telstra number on their mobile telephones, forming a relatively small part of the public, the facility was available to any member of the public who called the engaged number. Therefore, the music was being performed in a commercial setting, and the occasion was not private or domestic in character. Callers placed on hold constituted the copyright owner's public because individuals other than the callers were prepared to bear the cost of them having that facility. For the performance of the music to that audience, the copyright owner, APRA, would expect to receive payment even if not from members of the audience. Based upon these conclusions, the High Court held in favour of APRA in concluding Telstra's transmissions were to the public and dismissed Telstra's appeal.
Created using Powtoon.